Today we are going to discuss a situation where one gets to know that there is a victim of dowry or there is a victim of domestic violence and that person wants to take legal help, but that person doesn't know what is the legal route for that. Now, to understand the situation, we must first understand what is dowry and what is domestic violence. Now, in general parlance, of course, we understand these terms, but legally speaking, what is dowry has been defined in the 1961 Act of the Dowry Prohibition, and the domestic violence has been defined in the Domestic Violence Act of 2005. Dowry has been defined as any property or valuable security given or agreed to be given at the time of marriage, before marriage, or during the marriage. Concept of dowry finds mention in different acts. Of course, it finds mention in the Dowry Prohibition Act of 1961. It is also relevant for the Indian Penal Code, which is the primary criminal substantive law in India. The Dowry Prohibition Act penalizes giving or taking dowry, making any agreement to give or take dowry, demanding dowry. It also penalizes advertising for dowry. Now, in case any of the offense, as in giving or taking dowry, demanding dowry, or advertising for dowry, takes place, in that case, not only the aggrieved person, but the parent of that person, the relative of that person, or even a welfare organization can approach and file a complaint against the act. Well, there are some important points that must be remembered while we are discussing about dowry. Not all property or valuable security that is given or taken at the time of marriage or before the marriage or vice versa or after the marriage is dowry. So, what is dowry? So, a dowry is something which has a nexus with the consideration of marriage. It is so essential that if it is not given, the marriage won't take place. Firstly, this is very important to remember. Secondly, even the mere demand of dowry is an offense. So, even if there is a mere demand and the dowry has not been given or taken, even in that case, the offense has taken place. So, what does that mean? It means that all the gift items that were given at the time of marriage, that were willingly given, and which were not acting as a consideration for marriage, they were not so essential for the marriage to take place, and they were gift items, those will not be regarded as dowry per se. One interesting thing which is there, and the Dowry Prohibition Act records it, is that the meher which is given by the groom to a bride in a Muslim marriage as a consideration of marriage will not be regarded as dowry for the purpose of the Dowry Prohibition Act and within the Indian law. Now, coming to domestic violence is a special enactment which came up in 2005 with an objective to protect the rights of women who are victims of violence. Now, the Act defines an aggrieved person as a woman who is or has been living in domestic relationship with a person who she alleges has subjected her to domestic violence. The Act gives a very wide definition of domestic violence. It includes sexual abuse, physical abuse, emotional abuse, verbal abuse, to economic abuse in the definition of domestic violence. Now, if any person, not only a grieved person, gets to know that a domestic violence act has taken place, or there's a likelihood that a domestic violence act is about to take place or is being carried on, in that case, a complaint can be filed to a protection officer. Now, who is a protection officer? A protection officer is a unique feature of the Domestic Violence Act. A protection officer, as far as possible, should be a woman. She should assist the victim in the case. So, she should have all the details of the legal aid facilities, the medical facilities, the counseling facilities that are available, the shelter homes options that are available. She works under the supervision of the magistrate and reports to the magistrate. Now, complaints can also be filed to police officers, service providers, can also be filed to the magistrate directly. The magistrate is bound to dispose of the application within 60 days. The reliefs are different in nature when we talk about the Dowry Act and the Domestic Violence Act. The Dowry Act's relief are penal in nature, and the Domestic Violence Act's relief are not penal in nature per se. They are residence order, protection orders, compensations, all these things are there. And in case those orders are not followed, only in that case penal action comes in picture. One thing that is important to understand, and which is also common confusion, is that these reliefs are parallel in nature. So, for example, if somebody has filed a case under the Domestic Violence Act, it doesn't mean that that person cannot file a case under a different act. For example, 498A of IPC. So that window is always open to a person. And if a case is going on, for example, a case of DV is going on, that doesn't mean that a case of custody, although there is a provision of custody within the act, but even otherwise, it doesn't mean that a parallel proceeding cannot take place. So that was all about the Dowry Act and the Domestic Violence Act. Thank you.